A Delhi High Court has recently held that an instrument cannot be termed as a cheque if it does not specify a certain amount of the amount to be paid to a certain person. Thus, if the amount written on the instrument is absurd, the same cannot be called a cheque and it will not draw any legal consequences under the Negotiable Instruments Act. The observation was made by Additional Session Judge Praveen Singh of the Patiala House Court while hearing the revision petitions of an accused in the proceedings under Section 138 of the NI Act. In the present case, the cheque in question was drawn for an amount of 44 lakhs, 18 lakhs, 896 only. Thus, it was dishonored by the bank with the reason cheque irregularly drawn amount in words and figures differ. The revision had contended that the aforesaid amount cannot be ascertained and thus the document which was presented before the bank was neither a bill nor a cheque under Section 5 and 6 of the NI Act, respectively, and the offences US 138 NI Act could not have been attracted. The court observed that for an instrument to be a cheque, it has to satisfy the following 5 conditions of being valid under the NI Act. That is, number 1, an instrument in writing containing an unconditional order signed by the marker, directing a certain person to pay a certain sum of money, and the last one, only to or the order of a certain persons to the bearer of the instrument. When it comes to the condition number 4, the court noted the direction should be pay a certain sum of money. However, in the present case, the instrument is ambiguous. The court added the cheque was invalid on the face of it because of the uncertainty as to the amount written in words. It is not the case that the receiver could not have known the defect of the cheque when he received it or were due to some future act on the part of the withdrawee that the cheque was dishonored. Thus, the judgment of the Lakshmi DHM cannot come to the aid of the respondent in this case.